two cases which were consolidated on the sexual orientation question. The question here is whether Title VII's prohibition against employment discrimination, quote, because of sex, whether that encompasses discrimination based on an individual's sexual orientation. The transgender case has a similar question presented. It's phrased a little bit differently. And the question here is whether Title VII prohibits discrimination against transgender people either because of their status as transgender or under a sex stereotyping theory based on the case Price Waterhouse versus Hopkins. So this case comes up a lot in the briefs and at oral arguments. So let me give you a little background on it. It's an important case for Title VII. So this was the 1989 case involving Ann Hopkins. She was up for partner at Price Waterhouse and she was denied a promotion, basically told she needs to walk, talk, and dress more femininely. She's too aggressive. She should wear more makeup and jewelry. And she should take a class in charm school. So the Supreme Court says she can bring a claim under Title VII under gender stereotyping theory. And the question the Supreme Court says you need to ask is whether a female accountant would have been denied a promotion based on her aggressiveness and failure to wear jewelry and makeup if she had been a man. And of course the answer is no. And you can see the relation there to what we're talking about here with transgender status and sexual orientation. And I'll get to that a little bit more when I get to the arguments here. A couple more pieces of background, though, for these cases that are important. So the first is the second is this 1998 decision on Kale. It was a unanimous opinion authored by the late Justice Scalia, and it held, I think rather unremarkably, that Title VII covers male-on-male sexual harassment in the workplace. The reason this is relevant for our purposes is the court says, of course we recognize that male-on-male sexual harassment is not what Congress was principally concerned with in 1964 when it enacted Title VII. But statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils. And ultimately the provisions of our laws rather than principal concerns of our legislatures by which we are governed. So it matters what the law says, not what the legislators were worried about in 1964. So again, I think the relevance to the current issues is probably fairly obvious, but in 1964, Congress probably wasn't thinking about transgender status or sexual orientation when it enacted this statute. But this case tells us that, at least in theory, that shouldn't matter.